are exceedingly challenging for people who do not have the benefit of that legal education. I am not saying you cannot maneuver through the system, but I am recognizing that when you filed this lawsuit in August of 2026, or I'm sorry, August 26th of 2022, and you still have not served to the other side, you're not complying with the procedures, and going forward, it will not be this court's job or responsibility to educate you on what needs to happen. That's what I'm telling you. It was Abraham Lincoln who said, the person who represents themselves has a fool for a lawyer. I don't believe that if they have education in the law, but if they don't have any education in the law, I think our system is very, very complicated. So I welcome you to continue representing yourself. Is there anything else you would like me to know with regard to scheduling?
Um, could you please ask me about scheduling again? I was a little put off by the other comments. So scheduling, you would like to know, what was the question about?
Anything you want me to know about scheduling?
As far as when we would want discovery, or when
Correct?
we want pre-trial, or...
Exactly, all of that.
Well, we would like at least a week to get our discovery in. Make sure we have enough time for that. We have 8 hours of videotape, so we need time for a jury to look at that. We would need time to appoint the jurors, correct? I'm not sure exactly what you're asking, I guess, and I just don't want to leave anything out.
I understand that. I would strongly encourage you to read the rules of civil procedure with regard to discovery. They enable each party to have 30 days simply to respond to the other side's discovery. So the notion that this is going to be done in a week is unreasonable.
I did not mean a week. I meant
So
in order for us to gather our discovery and submit it, I wanted that much time at least. So.
But she said you could have 30 days, so...
30 days, yep. And
just wait. Mr. Lagering, I would ask that you not interrupt, and that is not what I said. I did not say she gets 30 days. I recommended both of you review the rules of civil procedure because there are 30-day deadlines to respond and to file those types of documents.
I misunderstood, Judge, sorry.
Ms. Kelly, from you or your client's perspective, is there anything else you would like me to know with regard to scheduling?
Your Honor, I would respectfully request that as this discussion has demonstrated, it has been very difficult to navigate this case thus far, and I believe given the lack of service, it's premature to set any scheduling orders. However, I would ask the court that if we do set a schedule, it be tightly controlled. That being said, Your Honor, would it be the court's prerogative to potentially schedule, as you said, there still could be service. I think at this point the court has it within its authority to dismiss for lack of proper service, and that's what I would ask the court to do first and foremost, is dismiss the case for lack of proper service, as you noted that this has been going on since August of 2022, and the plaintiffs have been provided ample opportunity and instructions from numerous sources to provide proper service. I also don't think proper service could actually ever be effective since the Sheriff's Department is not a legal entity subject to suit. That being said, Your Honor, if the court is inclined to continue holding the February date for a potential dispositive motion hearing, could we, depending on how this goes, set another scheduling conference in the alternative if the court is not inclined to dismiss for lack of proper service for February 22nd? If proper service is affected, I anticipate that we will be filing a motion to dismiss timely prior to that February 22nd hearing. That being said, at this point, we're not inclined to accept or waive service at this time, but I will have further discussions after the hearing.
Okay. So pursuant to the case of Angerhofer versus Stye, which is an unpublished decision, but I just remember it because it was my case that went up to the Court of Appeals, the court does have the right to manage its docket. I do intend to, for judicial economy, have today's hearing conducted as a scheduling conference. In the scheduling order that will be forthcoming, I will likely get it done yet today because this is my last hearing of the day. That I will put in a deadline in order for proper service to be effectuated. I will also incorporate dispositive motion deadlines. That will be February 22nd, 2023. I do anticipate that will happen at 10 a.m. It will be by remote. I know initially the motion said that it would be in person, but I am having that held by remote. And I will also put in other deadlines. I would also counsel individuals, mostly the plaintiffs, under Minnesota Rule of General Practice 114, alternative dispute resolution is also required if the dispositive motions are denied on both sides. Anything else for the record, Mr. Logreen?
No, Your Honor.
Ms. Acker?
No.
Ms. Kelly?
Nothing, Your Honor.
All right, we are adjourned. Thank you, everybody.
Thank you.
What's that all about? I was just looking. It's your job to create privacy. Look up the law. Don't run at me like that. You scared me. I don't appreciate that. That scared me. I don't feel safe. That's threatening. I don't appreciate your threatening behavior. I'll put that in your complaint now too. Jumpy fucking bastards in this building. Learn the law, boys. He fucking ran at me, that son of a bitch. He was gonna hit me. I wonder if this thing actually worked or not.
We didn't serve correctly. Why the fuck would they sit there and go on and on and on?
Let's complain about it.
Huh?
Maybe we'll be able to figure out how to have her recused now that she's been a fucking cunt. We'll just look into it.
That's too much for you to take.